Sheldon.
Thank you, my lord. My lords, my lady, just to briefly complete my submissions on contributory negligence, can I turn back to the evidence identified by the judge?
In the judgment, you mean?
In the judgment, as being sufficient to persuade him to make the finding of contributory fault. And in particular, paragraphs 234 to 235. My essential submission, just before turning to the detail of the reasons, is that the evidence identified by the judge was not sufficient to establish what was going through Mr. Jones's mind at the time of his death.
Sufficient.
I'm going to.
I'm
going with on careful consideration, my lord.
Reading the court.
Thank you, my lord. I'd do my best, but yes, sufficient is where I've ended up.
Okay, sufficient to what?
To establish what was going through Mr. Jones's mind at the time of his death, and in particular, was not sufficient to establish that he had retained the ability to make an informed choice not to act in the way he acted. And in my respectful submission, the evidence relied upon by the judge was barely relevant to those issues, let alone probative. The points that the judge identified as being relevant in this regard were firstly that Mr. Jones had had rational conversations in the days leading up to his death. I will come on to the hours in just a moment, but in the day, first of all, the days. And to answer my lady's question from before, the last in-person visit by Mr. Granville was on the 13th of April, and the last contact was a telephone call on the 15th of April. So the fact that he was having rational conversations days in the preceding days tells you nothing about what was going through his mind at West Hampstead train station. Nor does the fact that he had told people during the course of those previous conversations that he did not want to die. On the contrary, one might think, that only goes to show that there had been a significant change or deterioration in his mental state. The fact that he was moving purposefully, according to Dr. Morganti, on the CCTV, doesn't tell you anything other than at the relevant time he would appear to have resolved to kill himself. Indeed, one might think that hesitation was an indication that he may have retained sufficient ability to weigh up his options. The only expert evidence on the issue, other than Dr. Morganti's observations on the CCTV, which the learned judge records but doesn't comment on, paragraph 110.
Does anybody suggest that was expert evidence?
Well, it only
evidence given by an expert, but
only to that extent.
Yeah.
The only properly constituted expert evidence on the question was Dr. Meehan at page 137 of the supplementary bundle. The the long paragraph at the top of the page, if I can pick it up 5 lines down, there was no evidence to suggest a significant abatement of his anxiety. Perhaps I could just invite the court to read it, given the content. So that's what the judge's preferred expert thought about it.
What do you say about that?
Well, I say that indicates that Dr. Meehan's view was that he was not capable of forming a properly reasoned choice as to how to act.
It doesn't say that in quite those words, but you say that's...
I say that's the inference of it, and that's all there was in terms of expert evidence. Unbearable internal mental torment.
Yes, quite.
And external problems over which he felt he had no control. It's getting a long way towards that.
Yeah.
And we have the judge's own findings at paragraph 220, to which I referred for a different purpose earlier. I can infer that he felt a lack of hope, which was an important part of Dr. Meehan's analysis, but I don't know what else he was feeling. And Dr. Pereira's position, to the extent that it is relevant, paragraph 8.6 of our skeleton, and his evidence to the inquest was that he had no idea what was going through Mr. Jones's head at the time of his death. So in my submission,
Was there any other evidence before the inquest? If there was, it wasn't before the judge.
no.
Is there a question as to whether the coroner's views are admissible and relevant?
Well, I'm not. You will have gathered, my lord, that I'm not pressing that.
Yes, that's why.
It's the evidence, it's what the witness said, what Dr. Pereira said to them.
Yes, I'm to the extent that it may be relevant. I've cited what Dr. Pereira said to the coroner. I don't submit that the coroner's conclusion about a lack of intent was admissible. My submission is instead that there is nothing in any of this evidence, as summarised by the judge at 234 to 235, that would meet the test that I respectfully submit one should apply in these circumstances as derived from court.
No.
So, my lords, my lady, that's all I propose to say on contributory negligence. I wonder if I might trespass on your patience for 5 minutes to make one point about grounds 1 to 3, but it won't take very long.
Yes.
And the submission I make relates to ground 1, and the submission that we have made, from which of course I don't dissent, that there was that the consequence of Dr. Pereira's failure to conduct a proper handover was that Mr. Jones didn't have a proper treatment plan. And whilst I submit that that's right for the reasons my learned friend Ms. Gumbel has set out, in my submission we don't have to go that far to succeed on ground 1 for these short reasons. The finding that Dr. Pereira negligently failed to give a proper handover at the point of Mr. Jones's admission necessarily requires the judge to consider the question of what a competently conducted handover would have concluded. That's the straightforward factual causation part of the conventional clinical negligence analysis. Doctor doesn't do something they should have done. You have to then look at what would have happened had they done it, and then you assess the medical consequences of that action. So the question for the judge was a straightforward factual balance of probability one. If there had been a proper handover, what would Dr. Pereira have said to Dr. Bakshi? Now, he goes some way to answering that question at paragraphs 178 and 181, which I wonder if we could just briefly go back to. He refers, as my lords and lady have already pointed out, to good psychiatric practice.
Yes.
And can I look at paragraph 8a? The psychiatrist should facilitate the smooth transfer of care between services and provide a comprehensive summary of the clinical case to the receiving doctor professional. Then the following words bear underlining as well, to enable them to take over the safe management and treatment of the patient. And at 181, the judge distills that, or puts it in slightly more colloquial terms. By endorsing Dr. Pereira's evidence, I would have conveyed to Dr. Bakshi the history, the issues to do with this patient, my thoughts, views, ideas, the treatment I've tried, captured in, well, so on. Now, that's fine as far as it goes in terms of giving a general indication of what a handover would have consisted of, but it doesn't tell you anything specific about what the information would have been. But we know what the information would have been from the findings that the judge made, or the evidence he recorded at paragraph 84. And again, I wonder if, I know we've looked at it already, but could I just invite you to go back to it? Say, the judge says, save for a small number of mindfulness sessions, it was apparent that Mr. Jones had not received any psychotherapy since his admission.
84.
I'm so sorry, my lady.
It's my
80,
fault.
84.
It's my fault. Yep.
So, save for a small number of mindfulness sessions, it was apparent that Mr. Jones had not received any psychotherapy since his admission. Dr. Pereira accepted in evidence that he had envisaged appropriate therapy being an important part of Mr. Jones's effective inpatient treatment. He was reminded of the evidence at the inquest. Now, unless there should be any doubt about it, that was not a hindsight opinion by Dr. Pereira, as we can see from the relevant bit of his cross-examination on which the judge is basing this finding at page 303 of the supplementary bundle.
I'm so sorry, Mr. Sean, I missed the page number.
303.
Thank you.
At the top of the page, on the right-hand column in page 115, Dr. Pereira has asked, you envisage that appropriate therapy would be an important part of an effective treatment regime, didn't you? Yes. And then can we look at how you put it in the inquest?
But you're now dealing with a return.
Yes, my lady, but the sense of the question, as we will see when we come to the bit that follows, is that it was always going to be an important part of the treatment. So can we just briefly look how you put it in the inquest? You'll need volume J for that. And he's taken to it. Part of your evidence to the coroner. One of the things I should have mentioned is that I'm a trained cognitive behavioural therapist. So it's not only going to be medication, it was going to be a psychological intervention that could have made a huge difference. Yes, it was rather from that I took the point that in Mr. Jones's case, medication was important, but therapy was also very important, to which he agrees. And in my submission, as the judge correctly identified in paragraph 84, it was Dr. Pereira's view from the very outset that therapy would play an important role in Mr. Jones's inpatient treatment. And if any further confirmation of that were needed, at paragraph 26 of the judgment, the judge records the evidence from the pre-admission period the last outpatient consultation. Bottom of the paragraph, 3 lines up from the bottom. To Dr. Pereira's surprise, Mr. Jones said that a friend of his sister's had recommended a therapist, Colin Campbell, who he planned to see. Dr. Pereira thought this was a positive step. So from the very beginning, and as the judge recorded, Dr. Pereira was of the view that therapy was an important part of the inpatient treatment package. So we know, very often in factual causation arguments in clinical negligence, you have to just assume what would have happened on the basis of non-negligent care. But here we know on the evidence that whatever else Dr. Pereira would have said in that competently conducted handover, he would have said psychological therapy is going to be an important part of this man's treatment.
And then he's seen the next day and assessed for it.
Yes, but without his admitting consultant having given a properly constituted and recorded handover emphasising the importance of therapy in his treatment. And my lady, I would accept entirely that if that were the end of the story as far as the judge's analysis was concerned, then I might run into difficulty. But the judge went on in paragraph 224 to find what would have happened if Mr. Jones had been admitted with a clear recommendation or clear instruction from his admitting consultant that psychotherapy was an important part of the treatment regime. I'm not going to repeat my learned friend's questions about bipolar, the diagnosis doesn't matter. He actually finds what would have happened at 224.4. What would have happened if Mr. Jones had gone in with a clear recommendation from his admitting, treating consultant that therapy was to be a centrally important part of his treatment plan? And that is exactly what Dr. Pereira says he would have said in the course of a properly constituted handover and recorded.
So where does that leave the finding at 191?
Well, my lord, it doesn't really affect the finding at 191 in that I can live with 191. Because if we go through the various elements that my lord went through, it was agreed that Mr. Jones would be admitted. I'm not satisfied that Dr. Pereira had a real opportunity to work on a care or treatment plan as an inpatient with him. Okay, maybe he didn't have enough time to work up a fully constituted treatment plan. Nor did he have time to assess cooperation with the group therapy programme. Don't particularly have a problem with that. And I don't have a problem with the fact that it was Dr. Bakshi who was responsible for his care when Mr. Jones, Dr. Pereira was on leave. My proposition is independent of all of that, which is that the admitting consultant in a properly conducted and recorded handover has said to the hospital that he's admitting this patient to, therapy is going to be an important part of his treatment. And the judge himself in 224, regardless of 191, says what would have happened in that scenario.
So is it the first sentence of 192 that you have to quarrel with?
I do, my lord, because the error in my submission, in light of what I've just said, comes in at 192, first and second sentence.
Yeah.
because the judge asked himself the wrong question. All he had to ask himself was, in factual causation terms, what on the balance of probabilities would Dr. Pereira have said in this handover, and what would have been recorded? He didn't need to ask himself whether Dr. Bakshi was negligent or not negligent. He just needed to ask himself, what would Dr. Pereira have said? And he'd answered that question at 84. And then he had answered the subsequent question of what that would have led to at 224.4. And he got sidetracked by thinking that he somehow had to work out whether Dr. Bakshi was negligent or not, when he didn't. So 191 is fine. 192 is where the error is. Either the judge just didn't understand that he had to ask himself the factual causation question, what would the handover have included, or he mistakenly felt that the answer to that question was somehow bound up with an assessment of the standard of care of Dr. Bakshi. And in my respectful submission, two things flow from that, alternative things. My primary submission is that's but for causation established on ground one.
Is satisfied.
Satisfied. My backup submission, material contribution, well, he should have then said, well, okay, if what we're dealing with here is a man who received no effective treatment for 3 weeks, did the fact that his omitting consultant omitted to say he should have this treatment at the point of admission make a material contribution to that situation? And in my submission, of course it did, but the judge never asked himself that because he didn't understand material contribution.
The judge obviously regarded it as a different. He didn't have evidence as to what happened in the 3 weeks when he was admitted, because he wasn't asked to read Dr. Bakshi's statement, and there was no other. I mean, I assume I think he says he had the hospital notes, but he didn't have any evidence apart from that. And when one reads the judgment, it's evident the judge thought this was slightly frustrating because he could not. It was like a black box. You can see what happens before he goes in. You can see what happens when he comes out, but the judge couldn't make any findings at all about what happened during those 3 weeks.
Well, I'm so
Isn't
sorry.
the submission you just made requires us to fill in a gap which the judge didn't really fill in himself as to what would have happened if?
Well, in my respectful submission, my lord, the judge filled the gap himself
You didn't have to.
That's
at
224.
224 subparagraph 4 because he said if this man had gone in with a different diagnosis, brackets, which would have induced those treating him to identify psychotherapy as an important part of the treatment program, he would have had it and he would have survived.
Forgive me, I didn't mean to interrupt, but
Sorry,
then you're
sorry.
bringing in a wholly different factor, which is the different diagnosis.
Yes,
But it doesn't get you over the point, certainly as I understand it, that whatever you say should or shouldn't have been said in the adequate handover, there is an absolute dearth of evidence as to what happened in the intervening 3 weeks. And that was the difficulty for this judge, who really was meticulous in the way that he approached the evidence.
my lady, I do understand that, but it doesn't require my submission. The factual causation analysis does not require a detailed consideration of what did or didn't happen over the next 3 weeks. It just requires the judge to have turned his mind to the question, the simple factual question of what is likely on the balance of probabilities to have happened if the treating admitting consultant had said in a properly constituted and recorded handover, psychotherapy is a fundamentally important part of this man's treatment. And in my respectful submission, I do understand the point about the different diagnosis, but he tells us in 224 what would have happened, because that's the same essential factual scenario as him being admitted with a post-traumatic diagnosis, because in both scenarios, you're going to be saying therapy is very important.
I'm not sure you and Miss Gumble are on exactly the same page on this one.
Well, my lady, I think we differ
Yes.
only to the extent that I say it's not necessary to go as far as inserting a breach of duty for failure to ensure that a treatment plan is written up. I submit that the point succeeds at an earlier stage than that, where you have the admitting consultant telling the hospital they are admitting the patient to that this is the treatment that they want them to have. And
I'm sorry to interrupt, but is there a difference? 2244 is premised on there being a treatment plan for trauma, PTSD or the like. Post-traumatic diagnostic formulation.
yeah,
That, I assume, a treatment plan is something quite formal, which is to be adhered to. Is there a difference between that and what the judge is talking about in the handover, where he picks up Dr. Pereira's words of my ideas and thoughts and so on, which seems a much less prescriptive and formal stage of the process. And speaking for myself, not having your experience of this field, I don't find it self-evident what the judge says in 2244, had there been a treatment plan for post-traumatic diagnosis, can be directly read across, is the way you invite us to what would have happened had Dr. Pereira included in his handover his thoughts and ideas, because he is passing responsibilities. I think you accept it to Dr. Bakshi, and Dr. Bakshi has her own, is entitled to and obliged to have her own ideas as to what treatment should be.
My lord, can I seek to address that concern in this way very briefly? First of all, although on the face of it, it might seem like a failure to do a proper handover is some sort of administrative error in the course of the care of a patient. We have to remember here that what is happening is a consultant who is responsible for the patient has admitted their patient to hospital for treatment of a life-threatening condition before disappearing for 3 weeks. In those circumstances, the purpose of admission and the intention as to treatment is fundamentally important. Paragraph 178 of the guide, where the judge records the guidance, emphasises not just the importance of the handover, but the importance of record keeping. So, if, but for Dr. Pereira's negligence, there would have been a properly documented handover in which the admitting consultant had said, this is my patient whom I've been treating for over a month. I'm admitting him to hospital because I think his life is at risk. And this is the treatment that I think is fundamentally important for him to receive. Now, my lord, in my respectful submission, that is not just sort of ideas and hopes and fears. It's a very important, I would respectfully submit, vital part of the therapeutic arrangements. And when you then look at the situation where the doctor comes back 3 weeks later and the patient hasn't had any of the treatment, it is difficult in my respectful submission to see how the doctor's failure at the start is one he can be absolved of.
Thank you.
I don't want you to be under any misapprehension. I don't think a handover is the same as a treatment plan.
No, I accept that, my lady. I accept that. What would have happened in my respectful submission through Dr. Bakshi and probably Dr. Cam and whoever else was involved at the hospital would have had to work up the treatment plan in the days after admission.
Yes.
But they would have done so holding a documented handover from the admitting consultant saying what I've just said to my lord. I've been treating this man for over a month.
3 times. Seen him.
Yes. I've admitted him in life-threatening crisis, and I think he needs medication, I think he needs therapy.
But the judge.
So in those circumstances, the idea that he just wouldn't have had it.
No, I can go so far with you. The difficulty I see is this, that the judge found that Dr. Pereira was not in a position at the time of admission to carry out an assessment, and there is no criticism of that. That being so, whatever Dr. Pereira said in any handover, and he should have documented it, there's no two ways about that, it moves on once he is seen and assessed by Dr. Bakshi and no doubt by Dr. Cam and Dr. Appellant. So therefore the handover obviously is of importance, but it precedes any inpatient assessment.
Well, my lady, yes, but as it would have done in the event that he'd been admitted with a traumatic diagnosis. Of course there would have been that intervening stage, but the judge makes no bones about the fact that he's confident therapy would have happened in that second scenario. So how can it be that it wouldn't have happened in the first scenario as well? In circumstances where you've got essentially the same instruction.
But if the treatment plan is inchoate, there wasn't a treatment plan. The judge found there wasn't a treatment plan at this stage. How do you then get over the but-for problem?
Well, my lord, in my submission, I get over it, and I don't want to take up my own friend's time by repeating submission. So I'll make this point very very quickly. I get over it by saying that in circumstances where the admitting consultant, responsible consultant, whose patient this is, says, I'm admitting him for treatment for a life-threatening condition, which I think should consist of medication and therapy, then on the balance of probabilities, he's going to get medication and therapy.
Well, thank you very much. Ms. Gundle and Mr. Sheldon. Mr. Porter.
Well, my lady, can I start by repeating what I said during the trial? And that is expressing condolences on behalf of my client who was sat in court this morning.
He was.
On to a list of patients this afternoon. I know that Mr. James's widow is in court, so I think it's
Yes.
appropriate. It's been some time since the trial, but I repeat his very deep regret at what has occurred to Mr. Jones. But of course, this is a tragic case. That does not, of course, mean that everybody involved in Mr. Jones's care is responsible for the very sad outcome. My lord, I hold no brief, of course, for Dr. Bakshi or the hospital who settled the compromised case shortly before trial, and I remain entirely neutral as to their actions and what effect those might have had on the outcome. My lord, I propose, rather similarly to the scheme adopted by my learned friends, I propose to take the first 3 grounds of appeal. Clearly, they're all very closely related and relate to the question of quantum. My learned junior, Miss Mason Tom, will follow, taking the 4th ground, though your lordship's knowledge may have observed that a lot of what fell from my learned friend Mr. Sheldon in relation to that 4th ground of appeal is not presaged by the notice of appeal or the skeleton argument, or the way, indeed, the way in which the matter was put before the learned judge. But my
Well, your junior will no doubt be able to deal with that.
I have every confidence that she will, though she's had quite a busy short adjournment.
Well, Life at the bar.
Yeah.
We've all been there, Mr. Porter.
Yes, baptism of fire, my lady. But before I turn to ground one, can I make a very quick comment on breach of duty? And I think my lady in particular understands our position in relation to breach of duty. There's no appeal, and indeed no respondent's notice on breach of duty. Both sides appear to have accepted realistically that, at least in relation to breach, that the learned judge's findings fell well within the range of factual findings that he was well entitled to make on the evidence that he had before him. And there are no grounds of appeal that suggest that he should have found further breaches of duty relating to, for example, emphasising the importance of therapy on admission to the hospital, or anything of the like that we've heard a bit about this morning and just now. The findings on breach are there. We have what we have from the learned judge's judgment, and it's fair to note that the learned judge accepted fairly limited allegations on breach out of the very large number of allegations that were pleaded in the present trial. So many allegations were made, some were accepted, more were rejected. And in making his findings, of course, the learned judge was very well aware of and took into account shortcomings that he found in the quality of the evidence given by Dr. Pereira. We take that one firmly on the chin, but we say that has nothing to do with questions of causation. The questions of causation are factual, preeminently ones for the learned judge based on his assessment of the evidence that was before him, and particularly the evidence of the experts. So with that preliminary observation in relation to breaches of duty, can I turn to ground one, which I interpret as being a ground or an assertion that the judge was in effect bound to find causation proved, as to do otherwise was illogical and inconsistent with his own factual findings. Just a quick reminder, I'm sure, my lord, it's not really needed, but the allegations that were, the breaches that were proved were threefold. Firstly, Dr. Pereira not telling Mr. Jones on admission to hospital that he, Dr. Pereira, was going away for the following 3 weeks. Secondly, an inadequate handover to Dr. Bakshi on the 22nd of March, again on admission to hospital. And that is a handover which would have contained, should have contained, there was a telephone conversation the judge found, but it should have contained those matters that the judge has set out in his judgment. And thirdly, the slowness in arranging individual psychotherapy for Mr. Jones.
Yeah. Well, it's the second one that focuses.
The second one seems to be the one that's taken most time. And I'll try and focus on that. On the first one, the judge's findings were quite clear. I just note it's paragraphs 172 and 214. Didn't make a difference. That I think is fair enough. On the second finding that my learned friends rely upon so heavily, the learned judge considered very carefully, in a very careful judgment, the effects of the inadequate handover to Dr. Bakshi. And he considered carefully whether the absence of a properly documented and full handover should make Dr. Pereira responsible for the treatment given or not given by the hospital under the supervision of Dr. Bakshi in Dr. Pereira's absence. And the important findings are one that the court has already looked at. So I just mentioned that it's a paragraph 191, which is crucial. His findings and his findings that the learned judge was plainly more than entitled to make. The basic flaw in my learned friend's arguments, and I think this applies to Miss Gamble and Mr. Sheldon, is that they make insufficient distinction between group therapies that have been anticipated as part of the Bupa funded package. And the learned judge heard evidence that this was to be funded by health insurers. He heard evidence that one of Mr. Jones's many problems was financial. Individual one-to-one therapies were not routinely part of the Bupa package funded at the hospital. It was therefore anticipated, and this handover took place before Mr. Jones had declined to participate in group therapies, did indeed envisage that the usual package from the hospital would be delivered, including group therapy. And the judge was perfectly entitled to find in that context, as he did at paragraph 215, that deficiencies in the handover did not lead to measurable harm or contribute in any way to Mr. Jones's death.
Wasn't the handover even more important, Mr. Porter, arguably, given the uncertainty of the situation? Here was a man who was clearly, well, I say this, tell me if I'm wrong, clearly a source of great concern, about whom nobody had reached a clear view. In those circumstances, isn't a handover even more important, arguably?
Well, the circumstances of admission are dealt with some care by the learned judge, who pointed out, as the evidence clearly indicated, that the immediate reason for admission was a grave concern being expressed by Mr. Jones's family, to put him in a safe and secure place where his medication could be properly monitored, because he was, at various points prior to admission, either taking too much or too little of the medication that had been prescribed. And therapy was going to be part of the package. But there are differences, of course, between bipolar disorder and PTSD. The learned judge was entitled, he would have been entitled to find that the diagnosis made no difference. But on the other hand, he's perfectly entitled to form a view that different diagnoses would have made a difference. At 118 in his judgment, the learned judge, paragraph, haven't yet got to it. Where the learned judge records what Dr. Meehan was saying about diagnosis. Dr. Meehan, who is the expert that impressed the learned judge, drew a distinction between a biologically driven disorder, that is the middle of like bipolar, and a reactive problem like PTSD. And the medication is explained further over the page at 124. Dr. Meehan's criticism of a coherent medication plan. In answer to question and cross-examination, Dr. Meehan accepted, if contrary to his view, bipolar disorder was the right diagnosis, then the medication regime implemented by Dr. Pereira was appropriate for that condition. He considered lack of steps to establish that or discuss it constituted substandard care. So there does appear to be some distinction in a way in which psychiatrists set about treating biologically driven disorders, as Dr. Meehan put it, and reactive problems. And the central reason, as I mentioned a moment ago, it's clear from paragraph 169 in the learned judge's judgment, middle of that paragraph, the immediate reasons for admission. He reminded himself that there had been an initial discussion when Dr. Pereira first saw Mr. Jones. They discussed the possibility of hospital admission. And clear finding, there's no clear opportunity for Dr. Pereira to have a further discussion with Mr. Jones about the purpose and benefits of hospital admission before it took place. He acceded to the request by the parents, respecting their wishes as intelligent and engaged relatives acting in their son's best interest, for an admission for the obvious, immediate purpose of being supervised in a safe place where his medication could be given to him or reviewed as necessary. That is what was going on. It was a bit of an emergency during that first admission. And that forms part of the judge's reasoning as to why it was that the allegations that Dr. Pereira should have put together a treatment plan were likely not made out. So it wasn't, in all those circumstances, incumbent upon Dr. Pereira to mandate that that Mr. Jones was to receive psychotherapy, and that in the event which Dr. Pereira could not necessarily have predicted, that Mr. Jones simply refused to take part in any of that, there should have been immediate recourse to one-to-one therapy. So there is some difference between bipolar and PTSD, and there's nothing inherently wrong with the judge's conclusion that an admission for a reactive problem with psychotherapy, rather than medication, the forefront of everyone's minds, might have led to the hospital and Dr. Bakshi adopting a different course to that which they did, and hence the counterfactual comments of the judge that have been seized upon by our learned friends at 224 in the judgment. That, of course, minimises the importance of diagnosis, and it was clear that the evidence of Dr. Meehan was that diagnosis, or as he put it, diagnostic formulation, was important, and was important to delivering the correct treatment. Well, that is quite apparent from the end of the expert's joint statement. And it became apparent to me when listening to my learned friends' submissions that I might not have the right pagination in my supplementary bundle, but the lordships, my lady, will find, I hope, in the supplementary bundle. And I have it at page 539, but I suspect that might be a wrong reference.
Ours is 241 to 265.
Well, I'm very grateful. At the end of that document,
Internal page.
It's at our tab
wrong
5.
reference. There's a bit on causation. It's is it 519 double M? I thought that.
Yes, page 264.
Which is completely different from my copy.
Yes.
This is the end. The bottom of that page, when asked about causation, Dr. Meehan states that the deceased was admitted to hospital for intensive treatment, risk management, and safety netting. The scaffolding of care for the deceased in those circumstances required not one, but 3 safety nets. It's right at the outset: 1, adequate diagnostic formulation; 2, adequate treatment; 3, adequate ongoing multidisciplinary risk assessment and management. So even in the opinion of the claimant's own expert, he's not saying that it was treatment alone that would have made the difference. Even then, it's a tentative conclusion at the bottom of the page. Had these 3 dimensions, safety nets of the deceased care, been reasonable and not deficient, on the balance of probabilities, his death would have been avoided. And all that evidence, it was entirely appropriate for the learned judge to draw the conclusions that he did, drawing some distinction between what would have happened with a diagnosis of PTSD and what would have happened with a diagnosis of bipolar disorder. He was entitled to draw some distinction. Now, Lord, if I'm wrong about that, and if my learned friends are right to say that paragraph 224 is inconsistent with other parts of the judgment, then in my submission, I don't say this is necessary, but if I were wrong about that, the correct approach would be to, as it were, draw a line through paragraph 224, because the learned judge has expressly said this
If I'm wrong.
this opinion is only proffered on the
Yeah.
basis that he's wrong. So if we come before this court and the claimants were challenging the learned judge's finding that the diagnosis was within the test of reasonableness, and the court was satisfied that the diagnosis was a negligent diagnosis, well, then the judge is saying, here you are, bingo, you don't have to worry too much then about what would have happened. I'm going to save you the trouble of trying to contemplate what would happen in that event. Because the learned judge didn't know what points were going to be appealed and what points were not going to be appealed. In the event, his finding on no breach of duty relating to diagnosis has not been appealed, and so it is best to simply disregard paragraph 224 of his judgment. And every time my learned friends make a point about illogic, what they say is illogicality within the learned judge's judgment, they come back to 224. The rest of it is all entirely consistent. In my respectful submission, for the reasons I've given, the learned judge was perfectly entitled to draw a distinction between what would have happened with one diagnosis and another diagnosis, given the evidence he had, including that from Dr. Meeker, that diagnostic formulation is important. But if I'm wrong about that, and this court has to choose between two irreconcilable parts of the judgment, then plainly one chooses the part of the judgment that deals with the actual facts, rather than the part of the judgment which deals with the hypothetical, where the learned judge has attempted to be helpful and tell us what the answer is if he's wrong about dismissing allegations of breach of duty based on diagnosis. We aren't there, so we leave that out if necessary.
One just can't get away from the point that there is no challenge to the judge's finding that in respect of diagnosis that did not represent a breach of duty.
Yes. Yes, my lady, the lady puts what I'm trying to say better than I do. The simple point is 224 does not arise. We need not worry about 224.
What they're saying is that illustrates a flaw in the judge's reasoning elsewhere in the judgment, as I understand it. So they're not seeking to go behind that finding.
Well, the furthest they can go, I respectfully submit, is to say there's a flaw either in the parts of the judgment which dismiss causation, or in this part of the judgment. We of course can't appeal the comments the judge has made in 224. It's an irrelevance because nobody's questioning that there was no breach of duty relating to diagnosis. But if again, I've made my primary submission that there is a distinction to be made between the two diagnostic formulations. But if I'm completely wrong about that, and the judge has done something that's entirely internally inconsistent, I say, well, look, you put a line through 224, you don't put a line through his very careful and well-reasoned findings on causation.
Does that, what you've just said to us, turn on a distinction between there being a treatment plan and merely a handover on what's said on a proper handover? Because the way in which Mr. Sheldon put it this afternoon, he accepted that a handover is not a treatment plan. He said if it says the same thing, you should have therapy, brackets, and if group therapy doesn't work, that means you should have individual therapy. Really amounts to the same imperative. And in other words, is your
Yes.
I'm not clear to what extent the submission you've made that the judge was not being illogical in the two bits of his judgment is dependent on whether you treat one thing differently from another thing, or is it dependent on the difference between 224, which is about a treatment plan and the mandatory nature of that, and the handover, which is less imperative.
Well, but look, the diagnosis does affect at least the focus for the treatment, because a bipolar disorder demands pharmacological treatment.
In a way that trauma doesn't.
The way
If
trauma-
if it's not biological, if it doesn't have a biological cause, giving people
Yes.
drugs doesn't
No,
really.
if it's not the chemistry in your brain,
Yes.
it's what you've experienced in the past, then the focus should not be. This is why Dr. Meehan drew in diagnostic formulation in the first place. He says, oh, let's focus on medication. It's all completely wrong because he had PTSD.
Whereas if you have PTSD, really, it has to be
Well, talking therapy.
some form of therapy.
Well, I'm sure there are. I'm sure there are I'm sure there are medications that can
But
assist,
but the focus is
but
different.
the focus is on the talking therapies to get over what you've experienced in the past and to cope with that. Whereas if you've got a bipolar disorder, then there's a chemical imbalance in the brain. This is as I understand it, exactly what Dr. Meehan meant by a biologically driven disorder like bipolar and a reactive problem to events in one's life like PTSD. And that's why I drew attention to what Dr. Meehan himself had said on causation. Diagnostic formulation was important. It was one of the three strands that was required to be brought together to give Mr. Jones a fighting chance of surviving his unfortunate illness. I hope that
Yes.
answers your lordship's point.
Well, it's an answer. At some stage, I would like your comments on the difference between a treatment plan and a handover.
Well, the answer in my submission is to be found within the learned judge's judgment.
Yes.
But he did carefully look at what a handover should comprise, and he accepted what Dr. Pereira said about the content of a competent handover, which was sharing the treatments that had been tried and the thoughts about the patient and the like. Sounds a little bit like returning a brief to somebody else.
Well,
I mean, he
you
accepted.
don't. No, I'm sorry.
No, sorry. No, I mean, he accepted what Dr. Pereira said should have been in it, but didn't necessarily go any further than that.
Yes, he made no the breach of duty findings only went so far, and they did not go so far as to say you should have got involved in the treatment plan. Indeed, on the contrary, said there was no time for that. So the judge legitimately draws a distinction between the handover and the treatment plan. And as we pointed out in our skeleton argument, Dr. Pereira wasn't going away and leaving Mr. Jones unsupervised or uncared for a period of 4 weeks. He was leaving Mr. Jones in the care of the hospital supervised by Dr. Bakshi.
where precisely did the judge draw this distinction between the handover and a treatment plan?
Well, I know he deals with handover at a part that we've already.
He does. So I've got a finger in paragraph 178, Mr. Porter.
Yes.
So
Thank you.
where we're coming back to.
Yes, and it's and 181. I would have conveyed to Dr. Bakshi the history, the issues to the patient, my thoughts, views, ideas, treatments that I tried, which is captured in her notes after she saw him on the 23rd of March in the 19th. That's what that would not do as a treatment plan, because it doesn't say what the plan for future treatment is. It provides the background.
Yes. So I think you've told us that the judge drew a distinction between the handover and a treatment plan. I may have misheard you.
Well, I may.
If he did, I'd like to know where it is.
I may have misspoken.
Well, it's implicit in 191, where he says that he's not satisfied that Dr. Pereira had a real opportunity to work on it.
Yes, I mean, whatever it was, Dr. Pereira did not have an opportunity to work on it.
And that picks up what he says at 170, where he says
Yes.
there wasn't a negligent failure to assess.
Yes, 181 is a clear indication of what the judge was finding a handover was. And clearly that was not a treatment plan, because the judge finds that he's not satisfied that Dr. Pereira had an opportunity to
I mean,
work
isn't
on
there
a treatment plan.
always, as soon as a patient walks in the hospital door, there is the doctor starts thinking about what I'm going to do. So the plan, it doesn't sort of, there's no point, is there, where there is no plan at all, and then a crystallized plan which is followed. That's not how medicine works, is it? It's an evolving picture from the moment that, in all cases.
Yes, but it's evolving very rapidly at the point that Mr. Jones reaches a crisis, which leads the family to say, look, you must take him into hospital. That is an option that had been discussed with both Mr. Jones and the family prior to the admission to hospital, and it was implemented in a hurry when Mr. Jones deteriorated immediately prior to his admission and immediately prior to Dr. Pereira's period of holiday.
I think the appellant's case is it was clear that whatever the diagnosis, it was always clear, I'm paraphrasing, probably inaccurately, that he needed therapy of some sort.
Yes.
At the date he handed over, he hadn't had an opportunity to work on the plan or discuss with Mr. Jones whether he'd participate in the group therapy. So it was an inchoate plan for therapy, but wasn't it always a plan for therapy? At some
Yes,
point?
because group therapy is one of
Yeah,
the.
that's
that's
I think
part of the package.
yeah.
That comes automatically with admission to the Nightingale Hospital. So, Dr. Pereira has departed the scene when the circumstances change, and Mr. Jones is staying in his room, or he's going off to chambers, or he's leaving the hospital by day, and he's not participating in the many hours of group therapy that the hospital makes available for him. And it's at that point, and not before, that minds should have turned to individual therapy for Mr. Jones. At that point, of course, Dr. Pereira was off the scene.
Well, they should have turned the next day, the 23rd of March, if the note made by Dr. Cam is correct, where he's saying he doesn't want group therapy, he wants one-to-one.
Yes, that's the hospital and Dr. Bakshi.
No, I've got that point.
Yes.
Yeah. I mean, by then Dr. Pereira's gone.
He has.
And the same point is made in the note on the 29th by Dr. Kane, that
Yes.
Mr. Jones doesn't want group therapy, he wants one-to-one.
Yes.
And something happens, and it's not for this court to speculate, but Dr. Bakshi gives what are described as two mindfulness sessions.
She does, yes. So, well, the learned judge was correct in my submission to find that that was not something that could be laid at the door of Dr. Pereira. As I've said, I can't really comment on whether it could legitimately be laid at the door of the hospital and or Dr. Bakshi, and the judge, for obvious reasons, didn't go there. But it wasn't Dr. Pereira's responsibility until he came back from his holiday. And then, of course, the learned judge makes the third criticism, which is that he wasn't quick enough to get onto the therapy. But, that's the third point of breach, which hasn't received quite so much emphasis from my learned friends, and on which the learned judge's findings are unassailable. Because Dr. Pereira took back control from Dr. Bakshi on a weekend. The handover from Dr. Bakshi did not communicate any urgency to Dr. Pereira. That's apparent from paragraphs 195 and 196 of the learned judge's judgment. So that being on a Monday, Dr. Pereira sees Mr. Jones and discusses therapies, tries to encourage him to take advantage of what was offered at the hospital. On Wednesday, he sees him again and gives an instruction to the hospital to arrange one-to-one therapy. Because, as he records in his note that day, because Mr. Jones is not attending the groups.
Yeah.
On Thursday,
Which of these dates? What's the Monday? What's the Wednesday?
if your lordship has our chronology, 46 full the just take it up at the bottom of page 48 in the call bundles. or the middle of that page, 8th, 9th is the weekend.
That's the
Friday,
weekend.
Saturday. Dr. Batchy went on holiday and Dr. Pereira took that responsibility.
Just give us a moment.
Yes, of course. Yes,
Carry on.
the lawyer, sorry. The 11th of April is the next entry. Dr. Pereira saw Mr. James at Nightingale Hospital for the first time since returning from leave is a Monday. The 13th, when Dr. Pereira sees Mr. Jones again during the ward round, is a Wednesday. And
That doesn't.
Dr.
yes.
Pereira recorded the instruction. This is an instruction the learned judge heard to the hospital for one-to-one as not attending groups. And then over the page, we're still on the Wednesday when Mr. Granville visits Mr. Jones. Then on the Thursday, Dr. Pereira receives an email from Mr. Jones Senior, which is in the supplemental bundle. I'm afraid my reference will be inaccurate. And then the following day is Friday. A meeting with the family is arranged on that Friday evening, as the learned judge heard as a direct consequence of the email from the Thursday. And then Mr. Jones is out of the hospital over the weekend, Saturday and Sunday, the 16th and 17th. He returns to the Nightingale Hospital on the Sunday evening, and tragedy strikes early on the Sunday morning. As my learned friends indicated,
Monday morning.
Monday morning, I beg your pardon, not sure what I said. As my learned friend has indicated, there is a telephone conversation with a friend, Mr. Granville, on the Friday evening. Correct me if I'm wrong. And then we also have in the supplemental bundle on the Sunday evening, the 17th, an email from Mr. Jones Senior to his son. So that everything happened quite quickly when Mr. Pereira returned from his holiday. Of course, realistically, there's no respondent's notice saying that the judge was wrong to find a breach of duty. We completely accept the learned judge's findings about breach of duty during that week. But the learned judge also was in that context more than entitled to find that, but for that breach, at most one session would have taken place, and the reference to that is the judgment, paragraph 2.
Well, the focus here, they haven't focused on the third.
They haven't really, but
I think it's the
might
same.
try and allow them a little time to reply.
Well,
and
it's
they
the
might
second.
change
It's the
tack.
second breach on which they focus.
And they,
I'll move on then.
well, the kernel of this is the question is that the judge's decision was the second that none of these breaches caused the damage. That's
Yes,
effective.
yes,
That's why
yes,
we're
yes,
here.
yes. The three breaches, and this was the third one, not doing sufficient to get one-to-one therapy on return from his holiday. And the learned judge, I won't dwell on it. Talking therapies take time to work, and the judge is quite entitled to find that
So looking at the judge's decision on causation in the breaches, when that, what's your submission?
What's your submission on?
Why was he right to conclude that the breaches, and perhaps particularly the second breach, did not cause the loss damage?
But because he sets it out with care in his judgment.
Well,
the
if we
second
look at
breach,
let's look at this,
not-
what he
not
says
made
about the
any-
second breach. The second breach seems to be dealt with. We're on page 86, aren't we? We'll come back to what he says about material contribution. I presume we want to deal with that next. But
yes,
on straightforward causation, the
yes.
second breach is dealt with in in 3 lines, isn't it? 4 lines of paragraph 215.
It's paragraph 215. Nor do I find the failure to
That-
give sufficient handle. Dr. Bash, was any
It
mention
follows
of-
inexorably from the fact that I have not heard any evidence about the merits or demerits of his care and treatment by Dr. Bakchi.
Well,
That's am I right? That is all he says about why.
it goes a bit further because he's described in detail, I've already taken the court to this, what a sufficient handover would have contained, and it would not have contained the treatment plan. So his finding is entirely justified. The most egregious part of the breach, if you like, was that neither psychiatrist made a note of the handover. There was never any doubt that. Sorry, I shouldn't put it that way. I should say that the learned judge's finding was that a telephone conversation did take place, but it was not adequately recorded by either psychiatrist. And in those circumstances, the judge was not prepared to accept that it had been an adequate handover. But he was quite entitled, given what he'd found about what an adequate handover would have entailed, he was quite entitled to find that the inadequacies of the handover did not cause any measurable harm or contribute to death, because of the whole history that Dr. Pereira then went away, leaving Mr. Jones in the care of an apparently competent consultant psychiatrist and an apparently competent private hospital.
Do you accept, given what the judge says about what a handover ought to contain, that it would, as Mr. Sheldon submitted, have included a statement by Dr. Pereira to Dr. Bakshi that in Dr. Pereira's view, therapy was indicated? Because that's one of the building blocks that Mr. Sheldon relied on this afternoon.
It wasn't expressly, I mean, that sounds like part of a treatment plan, so I suppose the short answer is no, but in any event, we're talking about therapy. Both consultant psychiatrists would have known that therapy was offered as part of the big package.
This is the
at the
point
Nightingale Hospital.
you started
So-
with, that you shouldn't elide the difference between therapy and individual therapy.
Precisely.
I'm sure.
And I started with making a comment on my own friend's submissions that they failed to make the distinction that has to be made between the group therapy, which Mr. Jones was repeatedly offered, and the individual therapy that he well, there's some evidence he would have accepted. But he was assessed, as my lady said, he was assessed the day after his admission by a psychotherapist at the hospital, with a view to providing appropriate therapy.
So what difference would it have made had Dr. Pereira said in black and white terms, well, my thinking at the moment is he should have therapy?
No difference. That lies, I suspect, behind the learned judge's finding that the inadequacies of handover did not make any difference, because everyone knew that group therapies were on offer at the Nightingale.
Mr. Porter, you make that statement, and I know I have read that group therapies were on offer. I think it was 35 hours a week. There was some reference.
Yes.
And I'm not asking you to do it now, but could you, when today is over, send a note to the court just identifying where in the judgment we can find that, please?
The 35 hours was certainly in evidence, my lady. I'm not confident it's in the judgment, but I will
Well,
look for it.
I have read Mr. Sheldon's cross-examination of Dr. Pereira, so would I find it there? All right.
Possibly.
Possibly, my lady. I'm absolutely confident it was in evidence.
Yes.
It's a lot of therapy. It struck me at the time as being a lot of therapy. That's almost a full-time job, 35 hours a week.
Well,
I'm
I knew
sure
I
we-
hadn't imagined it, but I couldn't, in fact, remember exactly where I'd read it.
My lady, I can't remember off the top of my head where that comes from, but we'll certainly send a note if that's helpful as to where that's to be found in the evidence. I'm afraid, even if I could lay my hands on it immediately, I'd probably have the wrong page reference in the supplemental bundle. So it's even possible it's in a document that we didn't think was important enough to put in a bundle. But if that's we'll track that down. There was certainly there was many hours of therapy on offer. And certainly, I recall the evidence being when Dr. Pereira came back, he was understandably disappointed that Mr. Jones had not availed himself of any of this therapy. The problem only really arises when it becomes apparent that Mr. Jones is not going to. This isn't intended to be critical of Mr. Jones. It may well have been part of his illness, but he was not willing to cooperate with the treatment that was on offer from the hospital. Indeed, he preferred to leave the hospital during the day, even going to chambers. And when not leaving the hospital, he preferred to be isolated in his room, working or at least attempting to work. That was the evidence before the judge. It was obviously unsatisfactory, but this was happening over a period of weeks that Dr. Pereira was not responsible. But I hope that answers why we say the learned judge was quite correct in his conclusions on causation. There were certainly conclusions on causation he was entitled to make, and they boiled down to factual conclusions that should not be interfered with. Like, I'm conscious that we're starting to get behind time, so I can try, unless I can help further on ground one.
Well, you probably dealt with ground one. It sounds as though you think you have.
I think I possibly have.
And ground two is really ground one in dressed up in other clothing, isn't it? Do you want to say anything about Hodson? If not,
I mean, only that this is perhaps an appropriate point. The court won't need reminding of this, but the principles authoritatively set out by the Supreme Court in Crady, which was the decision from Scotland, where the Inner House had inappropriately interfered with factual findings and charges. We've put that in the authority manual. We've highlighted some passages. I make the point only that great respect has to be given to findings of fact by the trial judge. So we've highlighted passages at page 214 and 215
Thank you.
in the bundle.
Can I just say, page 304 of the supplementary bundle, internal page 119 is the reference to the
Thank you very much
authority
indeed.
grant.
I'm very grateful to my lady
Thank
friend. I'm relieved that she's been
following your
that
submission.
instead of listening to my submissions. But I hope, my lady, that spares us the job that we had set for us this afternoon. Thank you very much.
Do you want to come
Can
up?
I- sorry.
You can't, no, come.
Just add to that, page 28 of the supplementary bundle, there's another reference which I think is in Dr. Pereira's witness statement.
Thank you, my lord.
Now, material
So, material contribution. Now, the learned judge dealt with that quite shortly, but also quite correctly. Paragraphs 210 to 212 in his judgment. My learned junior, with her customary industry, has checked the claimant's opening notes from trial, and my learned friends did indeed advance at trial the case that if, and it is conditional, if the court was unable to decide causation on the but-for test, then he should consider material contribution. My learned friend Ms. Gumbel came close to accepting that in answer to a question from my lord this morning, but I'm not entirely sure, based on submissions that have been made, that they aren't seeking to
have their cake and eat it.
exactly, that if the but-for test is determined in their favour, they say go no further. If the but-for test is determined against them, well, let's look at material contribution. And that's not right on the authorities. If it is possible to determine a question of causation on the balance of probabilities, then that is what the judge will do and what the judge has done in this case. So the learned judge was quite correct in his short but succinct analysis of Williams and Bailey is quite accurate.
Well,
Even in Bailey, yes.
if the judge determines on a balanced probabilities, the but-for, on applying the but-for test, that the causation is established. That's the end of it. isn't
Yes.
it? But what about if the court finds itself unable to determine on a balanced probabilities that the but-for test is satisfied? Isn't that the point at which you have to consider material contribution? Surely, isn't it logical to say you would only need to consider it if it can't be established on ordinary but-for principles?
Yes, my lord, but the learned judge was clear that he could make findings on causation on the classic Hodson but-for principles. And he said, therefore, that this is not that sort of case in 212. It's not the sort of case where it's close to the eggshell skull analysis that the Privy Council in Williams had of Bailey. I probably wouldn't be able to complain if the learned judge had said Mr. Jones was in a very vulnerable situation where anything could have sparked this off and had the equivalent of an eggshell skull, and that tipped him over the balance. Now, if he'd said that, that would have been a finding on the balance probabilities, and I would have struggled to appeal that. But that's not what he said. He made a clear decision that the breaches of duty that he'd identified and the balance probabilities did not make a difference. So he was quite right to say that we don't go to Bailey and Williams. My learned friend's taken you to, I think, all the passages that I would have taken you to in Bailey and indeed in Williams. I think she took you to paragraph 42 of the Privy Council's the board's decision in Williams, and she took you to the board statement at page 63 in our authorities bundle, all of which are to the effect that if a case can be determined on the balance of probabilities, then it will be determined on the balance of probabilities. And that's especially clear from what Lord Justice Waller, with whom Lord Justices Sedley and Smith agreed in Bailey, who acknowledged in a case my own friend, in a passage my own friends have already cited, that if a case can be decided on the balance of probabilities, it will be. So we don't need to get into the complex and difficult questions as to whether material contribution should apply in cases of suicide. It's not the same as forms of industrial disease where it has been applied thus far. Industrial disease or clinical oxygen starvation at birth are the classic examples. This is a classic Hodson case with the, I'm not sure we've been to this part of it, but it's tab 9 in the authorities bundle. In Hodson, with the nub of the authority being highlighted, the part we've highlighted in the speech of Lord Ackner, with whom Lord Brandon, Lord Brown, and Lord Goffel expressed agreement at page 172 in our authorities bundle. Your Lordships, my lady, have a highlighted passage where causation is an issue. The judge decides that issue on the balance of the probabilities, unless there is some special situation. There is no point or purpose in expressing himself in this that the plaintiff has achieved in establishing his cause of action. So we've also, and given the time of day, given that I must allow my learned junior some time, I won't take you to it unless you'd like me to do so, but there's another recent Supreme Court decision, Davies and Bourne J. It's got nothing to do with clinical negligence, but it's to do with it's to do with private nuisance. But the passages we've highlighted in that decision at tab 13 reaffirm the primacy of the but-for test on page 252, which is a classic illustration in the field of potential negligence, which is why we thought it might be of some help. But this is paragraph 57. Classic illustration of the application of the but-for test.
This is tab, just so we're catching up, tab
I'm so sorry,
13,
it's tab
page
13,
252.
page 253. The part we've highlighted.
Lord Stevens.
The parts we've highlighted read the purpose of the but-for test is to eliminate irrelevant causative factors. If the damage would have occurred in any event, then the defendant's breach of duty is eliminated as a cause. And the classic illustration of the but-for test is provided by a clinical negligence decision, that of Justice Newell in Barnes and Chelsea. So we do say that the starting point has got to be that if you can determine causation on the balance of probabilities, classic but-for test, then that is what the court is required to do, and that is exactly what the learned judge has done. I know my learned friends dismiss the first instance decision, the case of PPX, a decision of Mrs. Justice Whipple, as she then was. That's in tab 12. There's no indication in PPX, which may come back to in the context of contributory negligence.
Yeah.
I just wanted to make the point at page 236 in our bundle. Paragraph 53. Causation. The risk that a particular person, whether or not that person is under the care of a crisis team, will try to commit suicide is difficult to quantify. Certainly there are risk factors which might increase the likelihood and treatment options which might reduce it. But for causation to be established in this case, I have to be satisfied that it is more likely than not that with intervention following referral, this particular claimant would not have attempted to take his life on the 20th of May. That could be clearer, but for causation. Judges are, of course, very well used to weighing up human behaviour. There's absolutely no reason to inject confusion into this field of the law by extending the different concepts of material contribution to cases of suicide. And we've looked at several suicide cases, and none of them has the question of material contribution been canvassed. Judges have typically not had difficulty deciding these sad cases on classic, conventional, but-for tests of causation. Well, taking this at a bit of a canter, I want to try and finish by 3:30. So in summary, this is a careful and comprehensive judgment. One doesn't really need to look very far beyond the judgment itself. And the learned judge made findings on causation that he was perfectly entitled to make. And he cited the relevant law and correctly applied it. And in those circumstances, his decision should stand. Unless I can just refer on ground 1 to 3.
You're going to sit down.
Sit down and gratefully hand over to my learned junior to deal with contributory negligence.
Thank you. Yes, Ms. Mason-Tom.
Thank you, my lords, my lady. I'm hoping, given the time, I can deal with ground 4 relatively promptly. As you will have noticed from the grounds of appeal, the appeal against the finding of contributory negligence at ground 4 is not advanced on the basis that the learned judge misdirected himself as to the law, nor does the appellant skeleton argument raise the legal points that my learned friend raised just before the lunch break. But nevertheless, it's worth just clarifying the position on the law, given that that time was spent to go through the authorities. At the conclusion of his submissions on the law, my learned friend Mr. Sheldon set out 4 principles which were distilled from the authorities who took the court to.
Well, with a bit of Sheldon thrown in.
With some Sheldon thrown in, my lord. Now, rather than address every comment in the reports that my learned friend took you to, I'll actually confine my submissions on the law to those 4 principles because it
Yeah.
discloses there isn't that much between the parties on the applicable law. First, Mr. Sheldon said that if the defendant raises a plea of contributory negligence, then it's for the defendant to prove that allegation on the evidence. Well, that's uncontroversial, my lord. That's the burden of proof.
Agreed.
And the second, Mr. Sheldon said, the question for the court is whether the evidence establishes that the deceased has retained sufficient personal autonomy over their actions such that they can properly be regarded as being at fault. I point out at this stage that's not controversial, and it's also not materially different from the respondent's analysis of the law as set out at paragraph 46 of our skeleton argument, or indeed materially different from the principles that the learned judge set out that he extracted from Reeves and Call at paragraph 231 of the transcript. My lord, my ladies, we will be going to that section of the transcript that starts at 86.
Opening it out for us. Yes.
88.
Okay. So you're saying that doesn't. He didn't agree. It doesn't differ from what you say, 46, or what the judge said, 2-3.
Not in any material way, my lord, no.
Any material, right?
Mr. Shelton's third proposition was that assessing that question will require consideration not simply of whether the deceased had control over their physical actions, but whether they were mentally able to exercise an informed choice. Again, my lord, there's nothing in that that is controversial. Although the authorities do sometimes use the word automaton, and that's been adopted in our skeleton argument, it's clear in those authorities the court's not using it in the sense of sleepwalking or being unable to physically control the body, but is also involving a consideration of the degree to which the deceased has control over their emotions and actions and will appreciate what they're doing when they kill themselves. That is language of Lord Neuberger, taken directly from Call. And so Mr. Sheldon's third proposition is also not controversial.
Do you want to just, for our notes, highlight the paragraph in Call when Lord Neuberger said that?
Yes, my lord, that's paragraph 66.
Yes.
And then finally, my lord, Mr. Sheldon suggested that in a case in which the deceased's mental state has been impaired by the defendant's negligence, the defendant will need to adduce sufficient evidence to prove an allegation of contributory negligence. With the amendment suggested by the bench, that sufficient evidence is
That
already
was
required.
Sheldon amended by Nugee, I think.
Yes, that's a restatement of the burden of proof again, and therefore is not controversial.
Okay. Uncontroversial.
Were it to be put forward by my learned friend that the authorities support a higher burden of proof on the defendant in cases where the mental ill health is attributable in some way to the defendant negligence, that I'm afraid would be controversial.
So compelling would be controversial.
Compelling would have been controversial. It's not borne out by the authorities or indeed by principle. But as my learned friend has toned down that particular submission, there's nothing between us there either.
Okay.
So given that summary, that there's actually very little between the parties on the applicable law, I don't believe there's much more, unless it would assist the bench, that I need to say about the law, other than to briefly address PPX. And this can be brief. My learned friend pointed out that this is not binding. Of course, that is the case. It's a High Court decision and it's obiter, the relevant section. Neither the trial judge nor the respondents have ever suggested it was binding. However, what PPX is an illustration of the application of these uncontroversial principles of contributory negligence straightforwardly to a case very much like the one under consideration today. If my lady, you would like to turn to tab 12 of the authorities bundle, I believe my learned leader took you to a moment ago. And paragraph 54 of Mrs. Justice Whipple's judgment, it's right at the very end. Here we can see that having considered Reeves and considered Core, Mrs. Justice Whipple directed herself quite clearly that she must make a finding about the extent to which the deceased's personal autonomy was overborne by the impairment of his mind. That is, in essence, the same direction that the learned judge in this case gave himself as to the law, and it's in my submission wholly the correct one on the basis of the authorities. Turning then, if I may, away from the principles of the law that are broadly uncontroversial and to the application of those principles to the facts of this case. The question for this court is whether the learned judge's finding of contributory negligence was plainly wrong on the evidence available to him. Now, it goes without saying, my lord, I think that's McGrady again. This is a high bar, and the point is that an appellate court should be slow to find a trial judge's decision on a matter of the application of law to facts wrong, given that the trial judge has the inestimable benefit of hearing all the evidence. My lord, you've already been taken to the section of Mr. Justice Bourne's judgment where he addresses contributory negligence.
Yeah.
He sets out his conclusions at paragraphs 234 to 235 at page 90 of the core bundle. Before turning to the detail of that, to make an overarching point first, the reality of a deceased individual's mental state at any point in time is rarely, if ever, going to be amenable to direct evidence. Therefore, any trial judge considering a deduction for contributory negligence, which is open to them as we've seen from the authorities, will have to assess what evidence there is and to make appropriate inferences from that as to whether the relevant state of mind was present at the point of death. So with that in mind, we can turn to the judge's reasoning. In outline, the learned judge identifies four main factors at paragraphs 234 and 235. First, as you will have seen, he considers Mr. Jones's movements and interactions over the last days and hours before his life. He notes that Mr. Jones's interactions with others were rational, and that even on the morning of his death, even in the telephone call to the hospital, no more than 15 minutes before his death, there was no evidence that Mr. Jones's behaviour was in any way untoward. Second, the learned judge notes that Mr. Jones had been, in his last interactions with the first appellant and with his friend, Mr. Granville, planning for the future. And in my submission, that's relevant because it shows that his intellectual ability to appreciate what's going on around him and to respond was preserved to at least some extent at that point, which I accept was a few days before the unfortunate event occurred. But at that point, he was able to plan and to consider. Third, the learned judge refers to Dr. McGanty's description of Mr. Jones's demeanour on the station platform. I'd suggest that it's implied that that analysis of the CCTV footage was accepted by the judge. He refers to it twice in his judgment. And also, I don't believe Dr. Meehan ever gave a view on the CCTV itself, or indeed viewed it. The list of documents at the start of Dr. Meehan's report in the supplementary bundle lists the CCTV chronology, but it doesn't suggest he's actually watched the full footage. Dr. McGanty did.
Did the judge watch it?
No, I don't believe he did, or the court. So the only evidence as to the CCTV was Dr. McGanty's evidence, which is why, my lord, I suggest that it was implicitly accepted by the learned judge.
Was it a matter on which he could give an opinion professionally?
Yes, my lord, in that he reads into, but perhaps we can turn to it. Dr. Maganti's description is set out at paragraph 110 of the transcript on page 71 of the core bundle.
I'm sorry, 110 in the judgment.
110 in the judgment, yes, my lord. I'll leave you to read that for a moment.
Can I just say this? We're in particularly sensitive areas, and if at any time anyone wants to leave court, feel free.
It's probably not necessary to read it all out.
I wasn't going to, my lord, and I will try to avoid doing so where possible.
Mr. Sheldon, I think I can say this without referring to what's said. Mr. Sheldon's submission, as I understood it, was consistent with the interpretation he was putting forward, rather than Dr. Maganti's interpretation.
Sorry, my lord, could you rephrase that?
Well, that it's consistent with how to put it fairly. The fact that he seems calm, etc., is more consistent with the interpretation that the claimant put forward rather than yours.
I wouldn't accept that, my lord, in that if the question for the court is whether someone is acting in a way that they're making an informed choice, they appear to be reasonable, have capacity in a looser sense of the word, as we heard earlier, then acting calmly is not inconsistent with that. It may be it's also consistent with something else, but the learned judge appears to have taken Dr. Maganti's view on the CCTV as supportive of his evidence on contributory negligence. And certainly, we can see in this section, Dr. Maganti is drawing from the deceased's expression and movement a sense that he is not overtly appearing as depressive and does appear to be in control of his emotions, which is part of the test. Does that address your point, my lord?
I think it's your submission, certainly. I understand it.
And then finally, to return to the judge's judgment on the issue of contributory negligence, he notes that there was no evidence from the appellants or from anyone else that Mr. Jones had done anything in the throes of his illness without being aware of it. In other words, there was no evidence for the judge to find that at any time he was unable to understand what he was doing or was unable to control himself. In fact, the evidence seemed to suggest the opposite. So from these four factors, the learned judge concluded that although Mr. Jones was clearly unwell, and of course must have been unwell to make the tragic decision that he did, he retained a degree of autonomy in the sense required by Paul and the other authorities at the time of his death. Now, in my submission, the evidence identified by the judge was plainly sufficient to justify that opinion. It is true that some of the evidence relied on relates to earlier points in time, but that doesn't preclude the learned judge from finding that, on balance, the state of affairs that was illustrated by these facts, perhaps hours or days before, had not changed at the point of Mr. Jones's death. The totality of the evidence supported the conclusion that the judge drew. Now, against this reasoned conclusion, the appellants raise, from the grounds of appeal and the skeleton argument, 5 criticisms. The first was that the learned judge's decision was contrary to the finding of the coroner. Now, I understand that's not being pursued today, so we can ignore that for now. The second is that the finding was not supported by expert evidence. That comes from ground 4 itself. There's also a suggestion it wasn't supported by the evidence of Dr. Pereira to the inquest, that there was no suicide note or other evidence of planning, and finally, that the first respondent had not himself adduced evidence to support a finding of contributory negligence. My Lord, unless you prefer otherwise, I will take those in the order in which I've said them, some more briefly than others. As I've said, we can leave the coroner point to one side and turn directly to the appellant's second criticism. This requires us to consider the expert evidence that was before Mr. Justice Bourne. As well as relying on the opinion of Dr. Meehan, which the learned judge did not refer to in his judgment, at paragraph 8.4 of the appellant's skeleton argument, they suggest that because Dr. McGanty stated in cross-examination that he was not imputing blame to Mr. Jones, that the respondent's allegations of contributory negligence had, and I'm quoting here from the skeleton, been expressly and entirely disavowed by the respondent's own expert. That is not the case, I'm afraid, my lord. The reason that it's incorrect goes back to the nature of the analysis that the court is engaged in. Contributory negligence in cases of suicide is not about blame in the usual meaning of the word. It doesn't carry the necessarily morally loaded connotations that the concept does in general usage. And indeed, more than one judge in the authorities you've been taken to today expresses discomfort with the necessary use of terms like blame and fault in this setting, although it is legally correct terminology. As I've already emphasised, the question for the court is about whether or not the individual's autonomy is overridden, whether they retain a degree of understanding and control. That's important because at no point in Dr. McGanty's written evidence does he suggest that Mr. Jones was unable to appreciate what he was doing or unable to exercise control over himself. It is Dr. McGanty's opinion of the CCTV footage that the learned judge addressed when making his finding that Mr. Jones was calm and purposeful immediately before his suicide. There is some more detail to Dr. McGanty's evidence. That's on page 26 and 27 of Dr. McGanty's original report, on pages 204 and 205 of the supplemental bundle. I would take the same approach my learned friends have done, not read out that material if I may, but the last two paragraphs on page 204 of the supplemental bundle and the first on 205 is relevant. Thank you, my lord. As we can see from this, it's clear that Dr. McGanty's opinion was that Mr. Jones was capable of making a decision at the time he made the decision to end his life, and he was able to plan to the extent of getting himself to the train station and indeed to select his method. That's not the only evidence in Dr. McGanty's supplementary report, which is at tab 4 of the supplementary bundle. He considers that the correspondence and written material Mr. Jones produced in the days leading up to his death suggested that he was coherent and that his attention and concentration was intact. That's page 235 of the supplementary bundle. The point of those references, my lord, my lady, is that from his written evidence, it's clear that Dr. McGanty was of the view that Mr. Jones was aware and in control of his actions to some degree at the time of his death. and at no point in his oral evidence did Dr. McGanty depart from that view. Now, my learned friend's skeleton argument at paragraph 8.4 draws the court's attention to a section of the transcript from cross-examination. Unfortunately, the transcript referred to is not in the supplementary bundle. I'm not entirely sure why. But 5/104/1, which is the reference you're given, would take you to a place in the transcript where Dr. McGanty says he does not blame Mr. Jones for the action that he took. And he does say that more than once. But as a member of a caring profession, still less a member of a caring profession with a particular interest in self-inflicted deaths, which Dr. McGanty is, it is, in my suggestion, not surprising that he declined to frame his view in the way of blaming Mr. Jones for his death. But it's a very long way from declining to attribute moral blame to an individual's actions to expressly and entirely disavowing the respondent's legal argument on contributory negligence. That is a jump that was not supported, that is not sustainable on the basis of Dr. McGanty's oral evidence. To return to the list of the appellant's criticisms of the judgment, their third criticism is that the conclusion on contributory negligence was not sound because, in essence, Dr. Pereira didn't suggest so at the inquest. Now, the relevant section of the evidence from the interest is exerted at paragraph 8.6 of the appellant's skeleton. In essence, when Dr. Pereira was asked whether he thought Mr. Jones was in a state as to be able to understand the consequences of putting himself in front of a train, he said that he couldn't postulate. He didn't put it any further. Now, as I believe my learned friend acknowledged, that answer doesn't really take anyone very far. But in any event, any answer Dr. Pereira could give at that point would be of little, if any, relevance to the court's determination, because he'd be giving an opinion, which he wouldn't be entitled to do, as he wasn't called as an expert. Fourth, my lord, it's suggested by the appellants in their skeleton argument that because in the instant case there was no suicide note and no evidence of planning, this case could be determined from the distinguished from the case of PPX, on which the learned judge relied is a strong word, but he certainly referenced it. Now, as a preliminary point, I'd submit it's not actually correct to say that there was no evidence at all.
Well, you've taken us to Dr. McGinty.
Yes.
Is that right?
Yes, my lord, Dr. McGanty is very...
McGinty and his, without spelling it out, he made points which could be, you would say, consistent with indicating an element of planning.
Yes, my lord. So the suggestion that there is no evidence of this
Yeah.
isn't accurate on the evidence that was before the court. But the more important point is this. Even if it's accepted there was evidence of planning in PPX, and there's not in this case, that doesn't take the appellant's argument anywhere in particular. Planning or otherwise wasn't the basis on which Mrs. Justice Whipple decided whether or not to make a deduction for contributory negligence. As noted earlier, she correctly directed herself as to the relevant test. It was one of the factors she said she would have taken into account in determining the size of a reduction for contributory negligence, but it wasn't the only one. What Mrs. Justice Whipple engaged in was an overall assessment
So, do you want to look at PPX? Carol.
of the degree of autonomy in the suicidal act, which was exactly how Mr. Justice Bourne also approached this question. There's no suggestion that he considered himself bound to assess contributory or to find contributory negligence in the first place, and then if he found it, to assess it at 25%, because that's what Mrs. Justice Whipple did. There's no suggestion of that at all. And then finally, turning very briefly to the fifth criticism, that the respondent has not themselves adduced any evidence to support a finding of contributory negligence and therefore has failed to discharge the burden of proof. As will be apparent from my earlier submissions, it's the respondent's position that there was evidence before the court, sufficient evidence before the court, for Mr. Justice Bourne to reach the conclusion. he
Doesn't
did.
matter then, you say that he didn't, you didn't produce anything else.
No, there's no rule of law or logic to make that so, my lord. So, to conclude then, although I've emphasised that a finding of contributory negligence is not an imputation of blame or fault in the moral sense, it is nevertheless understandable that Mr. Justice Bourne's finding that Mr. Jones was in some degree legally responsible for his death will inevitably be difficult for his family to hear, and I do appreciate that. But that cannot blind the court to the fact that the conclusion the learned judge reached was based on a sound understanding of the law and was squarely supported by the evidence, written and oral, that was before the court. In the circumstances, it cannot be said that the learned judge's finding that had liability been established, a 25% deduction for contributory negligence would be appropriate, was plainly wrong or outside the generous ambit of decisions that a reasonable trial judge could make. And therefore I'd invite the court to dismiss the appeal on ground 4 as well as the earlier grounds.
Thank you very much. Yes, Ms. Gumble.
I've only two very short points to pick up on. The first is in relation to material contribution. Whilst it's said we're trying to have our cake and eat it, I would say that it's routine in clinical negligence cases to plead that the defendant's negligence caused or materially contributed to the injury, and to plead in the alternative the case of causing on the but-for basis or materially contributing in the alternative. And it's only when the but-for primary case fails the material contribution becomes relevant. It can't be said that that's not open to us to argue material contribution if we failed on the but-for test. Those are the very circumstances in every case where material contribution becomes relevant. It's because you failed on the but-for test, but it has to be an alternative, and it's not really having our cake and eating it. It's putting forward an alternative case, which is a standard approach, certainly in clinical negligence cases.
Well, I wonder, we just look very briefly at what was said in Bailey and where it was put.
It was described as the three alternatives at the end of the Court of Appeal.
So it's right at the end of Lord Justice Wallows, in paragraph
Page
46.
Page 46.
And the way he puts it there is, if the evidence demonstrates on a balance probabilities that the injuries would have occurred as a result of non-tortious cause or causes in any event, the claimant would have failed to establish that the tortious cause contributed. So, in those circumstances, the argument is material contribution doesn't arise. I think I've got that right.
I think what is said there is Hodson case exemplifies.
Yeah.
So,
But if it would have happened in any event because of a non-tortious cause, then material contribution does not arise.
yes, that's where nothing would have made any difference. So you obviously fail.
Yeah.
If the
And I think what is said is that the judge said that this case fell into that category. That is
but he,
what is he says the present case. That's what he meant, as I understand this is what Mr. Porter, I may be wrong. Mr. Porter's case is that is what the judge meant when he said it doesn't arise in this case. Am I right, Mr. Porter?
Absolutely.
I put it
yes.
inelegantly, but that is what.
Better than I did, my lord.
No, not better than you did.
But what we say was wrong in law is that because he could have found that it had caused the injury on a but-for basis, but he didn't, he can't go on to consider material contribution. And what we say is it's the very fact that he didn't find the but-for test satisfied that he does need to go on to consider the alternative. Because
Well, that earlier today I expressed a view which was perhaps sympathetic to that line, but Mr. Porter has put me back in my lane in that respect. He says that this is a case where the judge was able to conclude that it would have happened in any event. Am I right? I am right, Mr. Porter. That is your case.
quite what he says. What he says is,
When you say that,
because I could decide it on a but-for basis, I don't need to go on to consider, which is slightly different. Can I just go back to the paragraph? Sorry. I'm sorry, 212. This is having cited Williams and Bailey. In my judgment, this is not that sort of case, as it's possible to decide on the balance of probabilities whether death would have occurred in the absence of breaches of duties. So because it's possible to decide on a but-for basis, you don't go on to consider material contribution. But the fact that it's possible to decide, if you could have decided in the claimant's favour, then you wouldn't go on to decide it. But if you decide against the claimant, the fact that you might have decided in the claimant's favour can't mean that you don't go on to consider material contribution, because those are the very circumstances in which you do go on to consider material contribution. So that's why we say should at least have considered whether the breaches that he found did make a contribution, and he simply didn't go on to consider that at all. What should have followed is I decided that the claimant fails on a but-for basis, but do I consider that the breaches that I found made a material contribution to the outcome? And in particular, and that's where the third limb, the failure to get psychotherapy on the 10th of April, we would say should have been very significant as to material contribution, because of what Dr. Meehan says about the hopelessness and that getting even one section or even arranging it would have affected the helplessness.
The judge actually does say in relation to each of the three breaches that it neither caused nor contributed to his death. You find that at 214, 215 and 221.
But it's not in considering whether what he should have considered and what we were asking him to consider was whether it made him more like, whether it made a contribution to the decline in his condition, so as to make it more likely he would come to try and kill himself in circumstances where the underlying condition was the other feature. And we say that because we criticised 192, which is where he does say cannot find Dr. Pereira liable for any admissions in the treatment, whilst the lack of handover to Dr. Bakshi may have contributed to any admissions by her. I've not tried the question of whether there were any admissions by her. That's where the test is wrong, because he didn't need to find any admissions by Dr. Bakshi to contribute to. What he needed to find was the underlying condition deteriorated more because of the breach in relation to the handover. So that we say is the wrong test in terms of whether it contributed. The right test is whether the lack of therapy, whether he contributed to the lack of therapy being provided, and the lack of therapy being provided contributed to the decline in condition. And that he would have answered in a different way, because it's clear it did by the time he came back from leave.
Yes.
The
So-
only other
yeah.
point I was going to pick up on is of the point my learned friend makes in relation to the group therapy, that he anticipated he would get the group therapy. In our submission, you cannot simply ignore, unless you do strike out paragraph 224 altogether, that the judge's own conclusion was that if group therapy was rejected, individual therapy would have been arranged promptly. And to say that Dr. Pereira would only have anticipated group therapy, if it's right that in the handover he would have mentioned that he expected that the patient should have therapy, even if he had only got in mind group therapy, then from the judge's finding that if group therapy was rejected, he would have gone on to get individual therapy. That is what would have happened on a causation basis. And it is a finding. It's we don't accept it, but want to simply strike out that whole paragraph as part of the judge's thinking as to what would have happened on the basis that therapy was said to be important. Then it would have led to individual therapy. Those were the only points.
I'm so sorry, my lord. And I'm,
Yes,
I'm
yes.
conscious. Just three very short points on contributory negligence. The first one is that to the extent the court is assisted by an analysis of PPX, to which you were taken by my learned friend, could I invite you also to note paragraph 37 of Mrs. Justice Whipple's judgment? It's tab 12.
37. Facts.
Where she records the evidence in that case. Again, distressing in nature.
Yes.
So perhaps I can just
Yes.
flag
Well,
But the point, my lords, my lady, is that it's quite clear when she's referring at paragraph 54, her conclusion paragraph, as to the reasons why she thought that in this particular case, on this evidence, the suicidal act was undertaken by a person with capacity designed to occur, etc., carefully staged. That's what she was referring to.
yeah.
And her conclusion at 54, insofar as it may be relevant to my lord, my lady, has to be read together with 37 and the very specific facts of the case. Second, the short but obvious point that McGrady will have differing levels of force depending upon the nature of the issue and the nature of the underlying evidence. It of course has a great deal of force where the issue is a factual determination based upon witness evidence of fact that the judge has heard and the appeal court hasn't. But here, of course, there was no factual evidence going to the central issue of Mr. Jones's state of mind at the precise moment that he acted in the way he did. And in my respectful submission, this court is in no way disadvantaged as a result of not having heard any witnesses of fact give evidence about that. And then the third point is that although my learned friend very, I may say so, elegantly constructed an analysis of Dr. Maganti's expert evidence on this issue, drawn from various points of his original and supplementary report, none of that features in the judge's decision. All the judge does in relation to Dr. Maganti is to note without comment or analysis what Dr. Maganti said about the CCTV.
But that's a reference to the passage that Miss Mason-Tom took us to, isn't it?
Well, it is, my lord, except that Dr. Maganti went further in the passages you were taken to, and rather than simply giving his impression of what the CCTV footage revealed in terms of demeanour, so on, went further in expressing an expert opinion, potentially an expert opinion, as to the extent of mental turmoil that Mr. Jones was undergoing at the time. My point is simply that actually even on the CCTV issue, which we are agreed the judge referred to, he did so without any comment one way or the other as to what he thought the merits were of that analysis, whether he thought that Dr. Maganti was properly able as an expert to draw conclusions from a grainy bit of CCTV footage and so on. Those were the only three short points.
Thank you very much, Mr. Sheldon. Thank you to everybody, counsel who addressed us today, and to those who sit behind them for all the hard work that they've done in this case. And we're very grateful to counsel for the sensitive way in which they've argued this case. It's a very sad, difficult case, difficult for everybody listening to, of course, in particular the deceased's family. We're going to reserve our judgments. In due course, you will receive a draft copy in the usual way. That is to enable you to correct any typographical or minor factual errors. It's obviously not an opportunity to re-argue any points. The draft comes with an embargo at the top, which warns that the draft is confidential and must not be disclosed to anybody outside the group to whom it is disclosed. Unauthorized disclosure is a contempt of court. In due course, we will hand down, having received your corrections, we will hand down judgment electronically. There's no hearing and no need for anybody to attend. We'd be grateful when you get our draft judgment if you would endeavour to agree an order which reflects our decision and submit a draft order to us for approval. If there are any issues, ancillary issues that remain in dispute, please could you file short written submissions on those issues, and we will resolve them without hearing on the basis of written submissions only. Thank you very much.
All right.